I'm Cierra Bettens. This is APTN News InFocus. Today, we're talking private property and the BC court decision on Cowichan Tribes' Aboriginal title rights.
It was standing room only as a few hundred people showed up at the information session held by Richmond City Council. However, that information session turned heated.
Why did you guys not reach out to us? I'm asking you. You're the mayor. You're supposed to know everything that's going on in Richmond. I pay my taxes to you. Why did you not reach out to us?
Do the lawyers want to address that one?
Yes.
No, cool it, guys.
That was a scene at a meeting in Richmond, British Columbia, the epicenter of a court decision handed down in August that gave Aboriginal title rights to the Cowichan Tribes. And ever since the ruling, a lot of information has been put out on social media by politicians and members of the public alike, some of which you could classify as misinformation or scare tactics. People say they're going to lose their homes, and many seemingly aren't being corrected about that. At the same time, the decision is opening up a conversation about the limits to the public's commitments to reconciliation. Ahead of the meeting that you heard earlier, the Cowichan issued a letter stating they are not challenging the effectiveness or validity of title held by individual private landowners. And here's what Richmond Mayor Malcolm Brodie had to say about that letter.
The Cowichan issued a letter yesterday saying that really this meeting is overreaction and that basically that the landowners don't have to worry about anything. We very strongly disagree with that, with the sentiments in that letter.
To get to the bottom of this case, we reached out to Kate Gunn, a lawyer with the First Peoples Law in British Columbia, and she joins me now from Vancouver. Kate Gunn, thanks so much for joining us on InFocus.
Yeah, thank you for having me.
I'm wondering if we could just start at the beginning. Can you talk about when this case began?
Sure. So this case, the Cowichan Tribes case, was heard that the trial took place over a 5-year period from 2019 to 2023, and the decision was released this summer.
And how has it been unfolding since then? Can you give us a bit of a timeline?
Yeah. So I think the decision itself, it took place over 500 trial days and a 5-year period. When it was released, the decision itself is over 800 pages. So I think there was initial general taking stock of what the decision said, what it meant. What has been happening more recently, as I think we've been seeing across the country, but especially here in BC, has been rising concern expressed by private landowners and by the province and the city of Richmond about what the implications of the decision will be. And we also know that the parties are appealing the decision. So at some point, we don't have timelines yet, it will be heard by the BC Court of Appeal. And then given the magnitude of the issues at stake, I would anticipate it will be heard by the Supreme Court of Canada.
Mm-hmm. And so, this is a pretty big decision by the courts, and there's mention of a third party in the judge's decision. Can you talk a bit about who they are?
Yeah. So the Cowichan sought a declaration of Aboriginal title over lands that fall within what is now the city of Richmond. And it was Cowichan's traditional village site. And the lands that they sought a declaration of title over were lands owned by third parties, as well as the city of Richmond, the federal government, and the Vancouver Port Authority. And so one of the concerns that's come out of this is what the implications are for third parties that are not the city or the federal government. The Cowichan didn't seek any changes or any outcome related to the third parties. They only sought to have the return of those lands that were held by the city and by Canada. So what the decision says right now is that until there's a future court case, those private interests will just continue as they are. Whereas the interests that are held by the city and by Canada, the court found that those grants of fee simple are legally invalid and defective, and the court gave an 18-month period for Cowichan, the city, and the federal government to negotiate a transition of those lands to the Cowichan.
And I know, about 2 weeks ago, the Cowichan Tribes issued a statement to clear up misinformation about the case. I'm wondering, what has it been like to deal with, different people in media and politicians talking about the subject and having to clear up some misinformation around the case?
I mean, I think it's important to flag that I and our law firm, we're not directly involved in the case. So to the extent that there is challenges regarding some of the misinformation that's been coming about the outcome of the decision, that's largely falling on Cowichan. We do feel that there is some misinformation to be able to help correct. And so I think we've been trying to do that to the extent we can. And I think the thing that I've really noticed over the past couple of weeks is how much this decision and the outcome of it really is testing the public's commitment to reconciliation and I think the provincial governments as well. From our perspective, the decision, the judge really applied established law about what Aboriginal title is and what the implications of it are. But because it is starting to touch on interests that are held by third parties, we're really starting to see the provincial government's, I think, public stated commitments to reconciliation, to recognition of Indigenous people's rights really being put to the test when they perceive a threat or concern about how that could intersect with the interests of private individuals and companies.
Mm-hmm. What do you think this will mean in the long run? What will that look like?
I think it really depends on how the parties decide to proceed. So the decision is really important insofar as it affirms what I think a lot of people have understood already about what the Supreme Court has said about the nature of Aboriginal title. And that includes the fact that it can be used to invalidate fee simple interests. But the important thing is that in this decision, that's not what the Cowichan are seeking to do. And so right now, I think there's one path forward where the province and the federal government and the city of Richmond all come to the table and negotiate a resolution with Cowichan about the lands that are at issue in the title claim and really pave the way for a new kind of process that involves meaningful recognition of Aboriginal title, even when there's this complicated issue of fee simple. There's another path, of course, which I think looks a little bit more like what we're seeing the beginnings of, which is a lot more, I think, less reconciliation focused and a lot more likely to result in conflict. And that's the approach of raising alarms about what the decision could mean for private landowners and really bringing to the fore some of the less palatable underlying views that some people may have about Indigenous people's rights. And so I think we're hoping that the approach that's taken here is a nation-to-nation negotiation approach and not one that is more conflict-oriented.
Mm-hmm. And on a similar vein, how would you like the province to approach this leading into these negotiations?
Well, I think a lot of the current conflict, or at least the concerns that are being raised by private landowners, are the result in part of there being a gap between how the law is developed and what province of Canada have chosen to do in terms of recognition of Aboriginal title. So courts in Canada have said for decades now that the issue of Aboriginal title in British Columbia is outstanding, that it needs to be addressed, and that the Crown has a moral obligation to negotiate a resolution of that. But that hasn't happened with very limited exceptions. And so right now, I think it's understandable perhaps that private landowners would be surprised that this legal interest exists, but that doesn't change the reality that it does and that it needs to be addressed. And so I think that it would be the preferred approach would be that the province come to the table with not an extinguishment mindset, but with the mindset of Aboriginal title isn't going away. It exists because Indigenous people were here prior to the arrival of Europeans, and that regardless of whether it's inconvenient or politically challenging to address that interest in light of what has happened in subsequent decades, that it needs to be addressed and it needs to be addressed in a way that is fair and just and meets that objective of reconciliation.
Mm-hmm. And we also know that 2 First Nations are appealing this decision, and I'm wondering if you can speak to, why that is.
I don't have a lot of information. It's Tawasin First Nation, Musqueam First Nation, and I don't have a lot of specifics on the details, but my understanding is that the concerns that they raised in the course of the trial related to how Cowichan Aboriginal title could affect their, in the case of Tawasin, rights that are recognized under a modern treaty, and in the case of Musqueam, their own assertions of Aboriginal title and rights. And so I would anticipate that their appeals would focus on similar issues around how the fact that Cowichan has both declared Aboriginal title within a portion of their traditional lands and also now a declared Aboriginal right to fish on the south arm of the Fraser River, how that affects their rights.
Mm-hmm. And, moving forward, what are some of the next steps?
Yeah, so again, I think it really goes back to how the Crown chooses to proceed. I think the province and Richmond have been very clear that they intend to appeal the decision and they are appealing it. I'm not sure on what grounds at this point. I think whether they appeal it or not, there remains an invitation, but I think it's also a requirement that they engage in negotiation now and try to resolve this issue. And I think really that is the preferred outcome for everyone involved. It's helpful to have courts to clarify rights when necessary. But again, it was a 500+ day trial. It was a huge expenditure of resources for everyone involved and resulted in a very lengthy, very detailed decision. And so I think with that in hand, there shouldn't be a reason not to sit down and engage in those negotiations and find an actual solution. And I think importantly, in British Columbia, we have examples of what those can look like. So we hear sometimes from representatives from the province or Richmond that Aboriginal title and fee simple interests cannot coexist. But the fact is that they do in British Columbia, and the province has entered into agreements, for example, with the Haida and Haida Gwaii, which do recognize and provide for the coexistence of Aboriginal title and fee simple. So from a legal perspective, there is a solution that can be reached. I think the question is whether there's a political appetite for that to happen.
All right, Kate, well, that's all the time we have, but thank you so much for making the time and joining us today on InFocus.
Thank you so much.
This episode was produced by Mark Blackburn and edited by Jesse Andrushko. Charmaine Straker is the executive producer of APTN News InFocus. We want to know if you're enjoying the show. Please leave a rating and review. And if you have any comments or ideas, email them to infocus@aptn.ca. Also, give us a follow. It helps other people find the show. I'm Cierra Bettens. Thanks for listening. Talk to you next week.
Homeless people aren't hard to find in Winnipeg. They're on the sidewalks, in bus shelters, and down alleyways. They're living in tents and squatting in empty buildings. They're even sleeping in abandoned cars. But who are they? And why are they here? Find out in Our Relatives, Life on the Streets, hosted by me, Kathleen Martins. Listen on your favorite podcast player.